Hi, everyone. It's Becky, and thank you guys for tuning in. I am happy to introduce today's speaker, Robert Fechtman, who's an elder law and special needs attorney with 30 years experience. You don't look that old, Robert. That my husband Tom and I worked with to help create a trust for our daughter Kate. And I know this is something that folks in our group are interested in. So Robert agreed to speak with us today. So I really appreciate that. And we're going to ask that you hold any questions until the end, and that everybody mute themselves so that we only hear Robert. So thank you for agreeing to speak with us, Robert, and take it away, please.
More than happy to. Becky told me that I should speak for about 25 minutes and then leave 5 minutes for questions at the end. You'll see I decided, therefore, to keep my slide presentation just to special needs trusts and ABLE accounts. And even then you'll see I could easily spend a couple of hours talking about this. And then there are other issues you might want to discuss at some point in the future, like powers of attorney and appointment of a healthcare representative and things like a supported decision-making agreement if your state allows that, and even housing issues, like if you think eventually you might buy a house for your child and whether you should put that in trust. So we could go on and on for hours, but I'm going to try to keep this to 25 minutes. We'll start out talking about various kinds of public benefits that might be available, because really that's the context of all the discussion of special needs trusts and ABLE accounts is, do I need to have a special needs trust or an ABLE account to keep the public benefits that I'm receiving? So I have a little bit of a laundry list of the different public benefits here. Many of my clients are very confused about the difference between Social Security disability insurance and SSI, or supplemental security income, and even the difference between Medicare and Medicaid. And you can see the government has named these programs very similarly. I'm sure that doesn't help. But the kind of threshold question, I think, in most cases is, what kind of Social Security is this child receiving, if any? And I'm going to guess that for most or all of you, if your child is receiving Social Security benefits, or if they're going to be receiving those benefits anytime soon, it's SSI. That's the needs-based kind of Social Security for people who are disabled but don't have a work record they can draw on. They haven't worked enough themselves. Their parents aren't disabled, deceased, or full retirement age drawing Social Security, so the child is getting SSI. That's a needs-based benefit, and it usually goes along with Medicaid, which you probably know is also a needs-based benefit. But then we can look forward to the future when at some point your child will probably qualify for Social Security disability insurance, and it'll technically be called childhood disability benefits, or sometimes you'll hear survivor's benefits if a parent has died, or dependence benefits if the parent is also disabled or has reached full retirement age and is drawing Social Security. And then the child's getting SSDI, it will be more money, almost certainly. And 2 years later, it will lead to Medicare eligibility. Medicare and SSDI are not needs-based benefits. So maybe at some point in the future, you'll have a child who really doesn't have much in the way of needs-based benefits. However, if they're on a Medicaid waiver, they're going to need to keep their eligibility for Medicaid. And for those of you that don't have a Medicaid waiver yet, the Medicaid waiver is the way that we provide Medicaid services outside of an institution like a nursing home or a group home. I call it a waiver home if it's a couple of roommates living together and they're all getting care and services through the same healthcare provider. And if you're on a Medicaid waiver, you probably really need that Medicaid waiver. It's the way that your housing and your care are paid for, and then you want to stay eligible for Medicaid. And in that situation, if you've got Medicare also, Medicaid pays your Medicare premiums, co-payments, and deductibles. In light of the time we have today, I just want to mention very briefly SNAP, which used to be called food stamps. It's the Supplemental Nutrition Assistance Program, and it's got some rules that we need to worry about. And Section 8 housing, that's an income sensitive kind of housing where you get a subsidy that helps you pay your rent. And if you have a lot of income, that will reduce your subsidy maybe to zero. And you want to think about that if you've got income coming in or if you have assets that are generating income. So unfortunately, that's all the time I think I have to spend on those issues today. We're going to talk about special needs trusts, and we're also going to talk about the way those trusts are affected by your assets or resources, the income that you're receiving. And then there's something called in-kind distributions, which I hope we'll have time to talk about. That's where the parents or anyone else, including a special needs trust, might be helping with food, clothing, and shelter. And if the parents or the trust are helping with food, clothing, and shelter, that might have an impact on the amount of benefits that the individual is receiving, can reduce the SSI, could count as income for Medicaid purposes. And so we don't like to make in-kind distributions if we can help it, although in-kind distributions are much better than income, which would reduce the benefits even more. When it comes to making in-kind distributions, I think we'll have time to discuss why the ABLE account is a perfect vehicle for helping the kids, because distributions from the ABLE account don't count as in-kind distributions and won't reduce the benefits like SSI. Okay, special needs trusts. Generally, what a special needs trust is a trust that's designed to keep the beneficiary of the trust eligible for needs-based public benefits like Medicaid or SSI. There are several different kinds of special needs trusts. The kind that I do most often with families such as yours is what we call the third-party special needs trust. This is a trust that is meant to hold some third party's money, usually the parents or the grandparents. Could be a brother and sister. I've had aunts and uncles. I've even had great aunts and great uncles recently leave money to a disabled great niece or great nephew. And if they do it properly, if they leave it to the third party special needs trust, then whoever set up the third party special needs trust gets to decide what happens to any money that may be remaining in that trust at the time of the beneficiary's death, which you'll see as a big contrast with the first party or self-settled special needs trust. And I kind of doubt that many of you will ever have a first party special needs trust for your child, but think about any kind of situation where your child would come into money of their own. It could be an inheritance from a well-meaning person who didn't think to put it into the third party special needs trust for them. Or it could be that they're in some kind of an accident. I hope it wouldn't be a major one, but any kind of insurance settlement or a personal injury settlement that is payable to that child because they were injured, that's their money. And even, this will strike you as funny, but people who have battles with Social Security, which is not all that unusual, unfortunately, where it might take them a couple of years to determine that they're actually eligible for SSI. Once the Social Security Administration admits that they should have been eligible for SSI all along, then they'll pay a lump sum back payment. And I've seen those be as much as $20,000 or $30,000. Now, all of a sudden, this child has way more money than they're allowed to have in order to keep their needs-based public benefits. Medicaid in most states has a resource limit of $2,000. Indiana used to have a resource limit of $1,500, and I believe there are some other states that have different resource limits too, but most states have a resource limit of $2,000 for Medicaid, and the resource limit for SSI is $2,000 across the country. So if you've got your own money and you need to get on public benefits or you need to keep public benefits, you use the first party special needs trust. And there are a number of issues with that I don't know if I'll have much time to talk about today, but the most major issue is that with the first party trust, Congress says we have to have a clause in that trust that says when the beneficiary dies, if there's any money left in that trust at that time, First thing we have to do is reimburse the state or states that provided Medicaid assistance to that beneficiary during his or her lifetime. So that's a big difference between the third-party trust, where the parents, if they set it up, get to decide who else in the family gets the money when the child dies, and the first-party trust, where I always tell people to be realistic, that it may be that all of that money goes to the states to reimburse them for their Medicaid costs. Testamentary special needs trusts, I only listed here because there is a particular kind of special needs trust that we use if we get one member of a couple on Medicaid. Well, in that situation, the one who's on Medicaid can't have more than $2,000, but the other spouse can have any amount of money. And in that case, Congress says if the spouse who can have any amount of money because they're not on Medicaid, if they create a special needs trust in their will for the spouse who is on Medicaid, then if they happen to die first, they can leave that money to the surviving spouse in such a way they won't lose their benefits. And that's a third-party special needs trust, so it can go to the kids when both parents are deceased. Okay, I mentioned the first-party special needs trust, and I was really talking about what we call a D4A trust, because I'll just rattle off this law. It's 42 U.S.C. United States Code 1396 PD4A. And that's the kind of trust we were talking about a moment ago. In some states, including Indiana now, people who have gross monthly income greater than 3 times what SSI pays have to have a special trust, usually called a Miller Trust, because that was the name of the guy who fought the battle with the government. I'm glad he didn't have some kind of unusual name that we couldn't pronounce. But with the Miller Trust, that's the next paragraph in this federal statute. It's 42 U.S.C. 1396 PD4B. And then probably most of you have heard of the pooled special needs trusts in your state. In Indiana, the main pooled trust is called the Arc of Indiana Master Trust. And I know Indiana was one of the very first states to have a pooled special needs trust, but now every state has at least one, and there are quite a few pooled trusts that are trying to manage their pooled trust for everyone in every state. So that's a D4C trust, and you're welcome to consider using the D4C trust instead of the D4A trust if you wish, and get help from the pooled trust in managing the public benefits eligibility. And I wish we had more time to discuss all of this, so I'm just going to say, Becky, right now that I'd be more than happy to come back and talk to this group anytime you want to dig deeper on all of these issues, and also to discuss the issues we don't have time to get into today at all. The individual who creates the self-settled or first-party special needs trust has to be less than age 65. We already talked about the payback provision. I'm going to move on in the interest of time, because I know you're probably more interested in these third-party special needs trusts. We do them usually to provide benefits for somebody who's already on public benefits, like a child or a grandchild, in such a way that they don't lose their public benefits. But you could also put money into the third-party special needs trust for your own child if you ever needed to go on Medicaid. And I get that question a lot. Parents say, I'm really worried about there being enough money left over for my child. What if I have an expensive long-term care need and I find that I'm using up all my money to pay for my care? I'm not going to be able to leave any money for my child. Well, believe it or not, Congress says it's okay. You can give that money to that child during your lifetime, put it into a third-party special needs trust for them so they don't lose their benefits, and then you can go right on Medicaid if you need to, because there's no transfer penalty or period of ineligibility for Medicaid for you if you gave the money to a disabled person in trust. Just a couple of the basic rules about ways that we can and can't use special needs trust money. This probably goes without saying, but if you were the trustee for a special needs trust for a person who's on Medicaid and SSI, you wouldn't want to give them any of the money. That's going to act like income to them, and it's going to cause them to lose part or all of their public benefits. So really, I say no cash here on the slide, but really the other way of looking at that is that we buy things for the beneficiary, or we pay for things that they need. We don't give them the money, we buy it for them And that way it's not counted as income and they don't lose any of their benefits. And remember, I said earlier, food, clothing, and shelter can be called in-kind support and maintenance, and it can reduce the benefits. So we try not to pay for food, clothing, and shelter out of the trust if we can help it. And then I mentioned here the ordinary fiduciary obligations. I guess I mean by that if we've only got $100,000 in the trust, and that's all the money we're ever going to have, we need to be careful about the rate at which we spend the money, because the trustee is responsible to the beneficiary to try to make the money last. I've given you a little laundry list here on this slide of things that we could use the trust money for. And I'm just going to say, if you really think about it, we could use the special needs trust money for almost anything, subject to that fiduciary obligation that I mentioned earlier. We've got to be responsible with the money. But I could come up with a bunch of wacky things that I've used special needs trust money for, or that I know clients have used special needs trust money for, and there's been no impact on the benefits as long as we do it properly. And I mentioned at the bottom of this slide, this is a topic Becky will have me come back and talk about another time, but we can use the special needs trust money to buy a residence for the beneficiary to live in, modify a residence of some other family member if we need to add a room onto the house in order to accommodate the special needs child, or we could even buy a house for that child and put it into the trust before we die. And we can certainly pay for maintenance of the house and property taxes and all those sorts of things. So we can use the special needs trust money for almost anything. I mentioned an organization here called the Special Needs Alliance. I've been a member of the Special Needs Alliance since it was started in 2002. We started out with about 24 attorneys across the country who do the same kind of work that I do. And now we've got closer to 150, and we represent almost every state. So I urge you, if you want to know more about all of this, to go to the Special Needs Alliance website. It's specialneedsalliance.org. And I wonder if I've got a typo on my slide, or if the specialneedsalliance.com will take you to the .org website. If I've got a typo on here, I'm very sorry. But I mentioned it in particular, and I have a link to this trustee handbook that we've done for many years. We've even got a version in Spanish if that matters to you. But I've had many people across the country tell me how helpful this handbook is in telling you how to use a special needs trust once there's money in it. I've only got a few more minutes, so I'm going to take the last 5 minutes of my presentation to talk about ABLE accounts. And I wish I could see all of you, and I'd ask you for a show of hands about how many of you already know about ABLE accounts. They've only been around since 2016. The law was signed in 2015 at the end of the Obama administration, but no state had any ABLE program until 2016. And in Indiana, we didn't have an ABLE program until 2017 because our governor at that time was busy getting elected as the vice president. So he didn't do anything about it in 2016. So there aren't any ABLE programs that are anything but very new. But I think a lot of the states have gotten the hang of it now, and they know how to manage these programs. So look up your own state ABLE program. And I'm sure they're all like Indiana, where you can go on the website and you can get a lot more information about this than I have time to tell you about today. But I'll give you some bullet points. The ABLE accounts are a new kind of 529 plan. And you probably know a 529 plan is usually called a college savings plan. It's meant to pay for post-secondary educational expenses. That's Section 529 of the Internal Revenue Code. And Congress created a new section called 529A. So that's in the Internal Revenue Code, and allows us to set up these ABLE accounts. Instead of only being able to use the money for post-secondary educational expenses, though, IRS says we can use it for what they call qualified disability expenses, which includes food and shelter, communication, transportation, and I love this category of health and wellness because I like to joke with clients that health and wellness to me sounds like a cruise. If I could take a cruise right now, I'd be happier and healthier. And all joking aside, you could really use this ABLE money for just about anything that the beneficiary wants or needs. And one of the absolutely best things that I like about the ABLE account is that it's truly considered to be the beneficiary's own money, which means if you think of it this way, this is the very first time in the history of needs-based public benefits that somebody on a program like Medicaid or SSI can have access to more than $2,000. And they can even access that money in their ABLE account with a debit card. And I've got a lot of clients who use the debit card all the time. It's a great way to spend the money. And the beneficiary, if they're capable of this, can choose when to spend their ABLE money on themselves for whatever they wish. There are a couple of rules with the ABLE account that I want to make sure that you know before I'm finished in about 2 minutes here. First is that the onset of your disability has to be prior to age 26 until the year 2026, when that's going to go up to age 46. So you got to look at whether you became disabled prior to age 26 right now to see if you're eligible even to have an ABLE account. However, you can prove your disability by showing or certifying that you had some kind of diagnosis prior to age 26. You can self-certify. You may only have one ABLE account, so your grandparents can't set one up for you if you've already got one for yourself. But hey, this is way better than nothing. Contributions to the ABLE account are limited to whatever the annual gift tax exclusion is. You're probably thinking $10,000 when you think about how much you can give away every year with no gift tax, but that's been indexed for inflation, so it's up to $18,000 now. Anyone can contribute to the ABLE account. However, this is the last important point I have time to tell you about, which is that ABLE, with all the good things I just told you, there had to be a compromise with Congress, and they decided that the ABLE accounts are going to act like a first-party special needs trust. So regardless of who puts the money into the ABLE account at the time of the owner or beneficiary's death, we've got to reimburse the state or states that provided Medicaid assistance to that individual during their lifetime. And Becky, I think I timed that pretty well, and we've got about 5 minutes for questions.
Excellent, Robert. Thank you.
I'm going to stop recording really quick, Robert. So I'm going to do that and let you guys take over.
Okay.
Okay.